Good. Hello everyone. Welcome to the launch of patentpandas.org. And I am so excited to be here. Thanks to the Media Lab for allowing me to host this awesome event, and also kind of helping me through the crazy disasters that I'm about to share with you all to make this resource possible. First of all, I also want to thank the Berkman Klein Center, where I'm an affiliate right now, for also connecting to me to so many resources, again, that have made this possible. Many thanks to come later on in this presentation. So let's get started. One more thanks to Carol Lynn, who is my kind of co-author and co-pilot in the Patent Pandas project. Unfortunately, she's unable to join us tonight, and so I just want to give her a giant shout out because so much of this work would not have been possible without Carol. She's from the Cyber Law Clinic at Harvard Law School, and that's where she's a student. So, to get started, patents are kind of far away for many of us, including me, less so now, but to give you an idea of what it feels like, I've found this lovely video clip that I'm going to use for educational purposes only. So, let's see if we can get this to play. Oh no, oh wait, is there sound? Oh no, there's no sound. I'll just describe what's happening. So there's the girl, and she's just doing this funny dance, and the stork is like, "What do I not see? Oh my gosh, why is she so weird?" Glass! We are in a glass factory. That's why she's walking and running so weird. And then she's like, "Oh my god, storks can't see glass." And then, of course, there's the wolves coming. So this bird is me, and that's what it felt like so much of the time. That glass is patent law. It's invisible to me, but very, very important. And that girl is like all the lovely lawyers that I've been working with who do see the glass and who can help me navigate these invisible force fields that will smash my face. So that's what it's like to deal with patent law. And hopefully, I can share a little bit so that you do not have to smash into the glass as badly as I did. So, two stories. The first story is about LED stickers. This is what an LED sticker is. It's an LED light that's in the form of a sticker. It started out as a research project back when I was a student, a master's student here at the Media Lab, where my collaborators, Natalie Freed and Adam Sedapin, created a class project where we handmade stickers that are circuit elements, like sensors and outputs, including LED lights. And we made them in this fun interactive scrapbook. That was back in 2011. And then in 2013, I met my collaborator, Bunny Huang. We went to Shenzhen to explore manufacturing and see how we could use work with factories to scale up research projects and deploy them out into the world. And my project for that was the circuit stickers. And this time, instead of using a team of grad students, we were able to collaborate with factories and use manufacturing processes to produce these stickers. Here's an LED sticker at scale. And we were really excited that it actually worked. And so here is our first set of stickers. There's some LEDs, sensors, and even a programmable microcontroller. And normally these projects would live in the lab, but we decided to see if we could get them out into the world by doing a crowdfunding campaign. So we launched a crowdfunding campaign for circuit stickers on CrowdSupply in November 2013. And we were very, very delighted that our funding was successful. And 6 months later, in June of 2014, we were able to ship on time. And this is largely due to Bunny's extreme skill in getting things made very quickly and then shipped out. So that was great. And then we were able to get our stickers, our circuits, our papercraft all over the world, and now educators like these folks can start learning circuitry using arts and crafts, which was our intention with circuit stickers. And all was wonderful until, fast forward to February 2016, we get this email from an acquaintance that says, "Hey guys, there's this crazy, extremely broad patent that seems to cover your stickers, and it seems to be a ripoff of your work. Here's what it is." We checked out the patent. What was it? It was these things. These are called light seeds. They are also stickers that are LEDs. And they were created, it turns out, by one of our crowdfunding campaign backers, which we know because all of our backers are available on the crowdfunding website, which you can see right now. So this is the person that created those. And not only that, this person named Jill also created her own crowdfunding campaign in 2015. So to give you a comparison of what this is, here's our crowdfund video from 2013. So you see you lay down copper tape, so we're using craft materials to build circuits. You stick down the sticker, add a battery, it turns on, and it glows. And that's basically the idea behind circuit stickers. Oh, so now you can see this other one. Here's her video. Oh, there's no sound. Well, I'll just let it play anyway. Basically, she comes in, she describes how she did this work all on her own. You can go to Kickstarter and see the video yourself. Here she's using a pen to draw a circuit, and then she's going to add a sticker. We'll just go back. But you get the idea, but rather than confusing you guys with videos. So how did this happen? And what do you do when someone tries to patent your stuff? That's the important part, right? Well, first off, don't panic. That's the worst thing you can do. You want to send like an angry emailer to somebody, right? But actually, that's probably not going to help. It's one of those things where like you have the right to remain silent. Anything you say can and probably will be used against you. It's a little scary, but it felt a little bit like that situation. Next, with all that angry energy, you should make a list of prior art. So all the projects that you've done, that other people have done, that are related to this work that happened before, to prove that indeed the stuff happened before somebody tried to patent it. So this was what my prior art list looked like. Finally, you can then look up the patent on the USPTO website. It's called Public Pair. So we did that. We found the patent, and we found that she had filed her provisional. This is like the earliest, in August of 2014. This is months after we had shipped our product, many months after we had done the campaign that this person had backed. With this information, you're ready to find legal counsel, find an actual lawyer, an expert, someone who can actually help you. And that's super important because this is that glass is very invisible. You definitely need your, lawyer Sherpa to help you. So what we ended up doing is we tried to submit a letter. It had already passed examination, which means the patent was already accepted by the USPTO, but we thought maybe emailing the lawyer could help. We emailed the lawyer, showed them some of our prior art, and unfortunately nothing happened, and the patent got granted in March of 2016. So despite our company, my research papers, all the news articles, the patent still passed. And it turns out it's because examiners have very little time to review a patent. They have 12 hours to read it, understand it, search for prior art, and then write everything up, which is not a whole lot of time. And as a result, things will be missed. In fact, it turns out they pretty much look right now mostly for other patents for prior art, which it makes sense because there's so much stuff out there. Let's start with patents, which are at least written in a legal way that's easy to cite. Of course, thankfully, there are now other projects that help. So a quick plug is the Prior Art Archive that was just started here at MIT with Cisco, where it allows people to submit non-patent prior art, and then the patent examiner will also look at that. So as that project is growing, hopefully that'll provide another avenue for examiners to find prior art that's not patents. Why? Because patents are really hard to get and expensive. So timelines are important when it comes to law. And just to review, we've got 2011, we started the project. 2013, we did our crowdfunding campaign. We shipped the sticker in 2014, June. A couple months later, our backer files a provisional patent. So this is like the simplest thing possible. And 2 years later, almost, February 2016, we find out that the application even exists. And a few weeks later, patent issues. So that was a sad story. But it's not over, because guess what? About a year ago, I get this email from Jill herself saying, hey, want to buy my LED stickers patent? Because, it's relevant to you. So at this point, we're like, what? So this actually, is about a year ago, and the patent is still active. This whole situation is still active, but actually we're okay. Why are we okay? Because we haven't gone after her. She hasn't come after us. We have so much prior art to defend ourselves with. We just kept making LED stickers as if the patent was not there. And so far, our company, Chibitronics, still continues to be able to do this and get our work out into the world. And that's kind of the important part for me, that we can continue to create, to innovate, and get our things out into the world, and do what's important, and not kind of get tangled up in these legal fights. So even though it's kind of shaky, to me, that's a win. So that's the first story. The second story is electronic pop-up books. So something else that I love is blending books with electronics. This is an electronic pop-up book project that I did back in 2010. It was my first project here as a grad student at the Media Lab, and it involved making sensors out of paper and adding lights and interactive elements to pop-up books that are also like programmed, make sound, glow, move. I also worked on adding electronics to sketchbook, so how do you sketch in circuitry, and explore telling stories using electronics. So here's a story about Ellie, the LED who dreams to be a star, and this is kind of the book prototype that that became. So in March of 2014, I was invited to go to a place called Google ATAP. It's kind of an exploratory small group within Google, and they were interested in new storytelling interfaces, and they were particularly interested in books and electronics as a way to tell stories. And so I went in there as a visit. At first I thought it was just visit the space, and frankly I got to meet my heroes. It was mind-blowing what they were doing there. It quickly turned into a job interview where I was meeting with people who were like, oh, you should work with us. So in my mind I was imagining like, oh, maybe I'll get to do a summer internship. This would be so cool. By the end of the day I was meeting with the director of the entire department, and she was offering me a job. She wanted me to start immediately because my work was relevant, and so there was that, and it was kind of amazing, right? However, I kind of came back. I would have had to take a break from my PhD. I was just in my first year, and so I asked many people for advice, and the answer basically was like, stay in school. Don't leave just to do this project at Google. So I decided to stay in school and pursue my PhD, which I'm very happy about. 2 years later, I get an email from a friend who's a paper engineer. She does pop-up books professionally, saying, hey, look, check this out. Turns out Google is applying for patents on pop-up books with electronics in them. And it happened to be picked up by a pop-up book blog because they're like, whoa, if Google is doing this, it's going to be so cool. Unfortunately, looked a little bit familiar because a couple of the inventors on this patent application are actually the same people who I spoke to during my visit. And when I visited them, I visited them in March, and their provisional was made in August of 2014, which is months after we'd spoken, and they did not cite any of my work in their patents. So just to give you a recap on the timeline, so 2009 made the pop-up book. March 2014, I went for what turned out to be the job interview. August 2014, they filed the provisional patent on the pop-up book. Note, August 2014 is also when the LED sticker patents were filed, and then in March 2016, it was basically about a few weeks after I found out about the first one, I found out about the second one, at which point I was like, wow. So a brief interlude. Head blanket because head desk hurts. And that's kind of how it felt. It was like, it wasn't even, bad anymore. It was just kind of absurd and funny that this was all happening at the same time, independently of each other. So here it is. Again, don't panic. When someone else is trying to patent your stuff, don't panic. Make a list of prior art, look up the application, and find legal counsel. Luckily, I had done all of this about 3 weeks ago, so I was much more calm the second time around. Here was my prior art list that I sent out to the lab. And the cool thing about prior art is as long as it's made and has a verifiable date, it doesn't have to be a big publication, it doesn't have to be yours, it works as prior art. In fact, a cool trick is if you have a website that you want to turn into prior art, submit it to the Wayback Machine, which is the Internet Archive, and that'll automatically stamp it and make it permanent. And that's like a cool trick that people use to make prior art. So just know that. And if the application hasn't been accepted, if it's not a patent yet, you can still submit prior art directly to the application. So that's a thing you can do. So we looked it up, and we found what it was. We found that it was submitted after I had visited, months after. Luckily, this is where the magical moment comes in. The director of the Media Lab, Joey, happened to know the director of ATAP directly, Regina. So we were able to contact her directly and make a connection and try to sort out this kind of hairy situation. So she was basically like, oh, there must be some misunderstanding. So, But we ended up getting in a call with their team. And I remember during this call, they actually offered, if they added me as an inventor to the patent, then would I be okay? And at the time, I was like, no, because I'm not the only person who works on pop-up books and technology. There's so many people. You have to add all of them, too. So I basically turned it down. What I didn't realize at the time is that there's a difference between an inventor and an assignee for patent. So the inventor is the person who comes up with the invention. They're like the designer. The assignee is who gets the rights to actually use the patent. So one way to think about it is an architect designs a house, but whoever owns the house actually lives in the house, and that's often not the architect. It's kind of the same situation here. So what would have happened is if I accepted, maybe, I would still be an inventor, but I would not actually be able to use my work legally because the rights might be owned by Google, right? So I accidentally dodged that one for like a totally different reason, but now I know, and that's something to know about. What ended up happening is in the middle, Regina actually left the company, but she thankfully put us in direct contact with the senior counsel of ATAP. And they took all that prior art, all that anger, energy that took to make, because it's like when this is happening, what else do? You make a list of prior art. They took it and they submitted it to the patent application. And then the application ended up being rejected, and now it's abandoned, which means it's in the system, but it's actually not a patent. And in fact, it's kind of cool because now it's prior art that's not a patent, which is the strongest prior art you can have if it's already in the system, which is kind of a good story. Something to note that I've also learned is that big companies actually often have bonuses for patents. So what does this mean? A lot of large companies have their own legal teams. If they they give people financial bonuses just for even disclosing work. If you get your patent, if you get your idea turned into a patent application, that's another bonus. If your patent issues, that's another bonus. So there's a lot of financial incentive to apply for patents. So maybe it's possible that they actually didn't care so much about the work, but wanted bonuses. Who knows? It's a very different thing. I mean, if grad students got bonuses for applying for patents, I suspect there would be a lot more patents coming out of universities. So, it is what it is. So what I learned is that even though I just want to make things and kind of ignore the legal side of making, it doesn't ignore me and it doesn't ignore you. And so what is this? It's patent law. And so what we did is to create patentpandas.org. And this is a website that shares all of these learnings, all of this kind of mess that we've all kind of gone through, and turns it into something hopefully friendly that everyone can benefit from. So with that, a quick kind of introduction. So here's the Patent Pandas. That will do. And also, before I proceed too much longer, let's go to about. I want to, oh, that's not what I meant. Hello? Is that, sorry, while I mess with my pointer. There. Whoop. All right, okay, awesome. So this is a website that was created collaboratively. All these cute panda drawings are drawn by my sister, May. So grateful for her creative contributions. It was co-written with Carol Lynn, who again, unfortunately couldn't be here, and Ira Winder, my partner, was the one who actually built up this beautiful website where everything lives and lives stably in a way that's easy to access. So this is Patent Pandas. Everything that we write on here has also been reviewed by law clinics. So we've had support from the Harvard Cyber Law Clinic, the Suffolk Law School Law Clinic, the University Southern California IP Law Clinic. We've had support from Andy Sellers here, who runs the MIT BU Law Clinic, so many law clinics. And I say this because it's important to know that there's resources out there, like, to help you. You are not alone when something bad happens. And so one of the things that we made sure to have on here is, where's my mouse? Here, which is, it's a list of pro bono resources. So these are free law clinics from schools or from volunteer lawyers groups across the US. And we're actually now contacting law firms who have their own individual pro bono programs, which means that they will do this for free to help you if you qualify. So if people are in trouble, they can find help. And so that was very important, and we're very, very, very grateful that all of these folks and more, every day continue to say, like, yes, please list us, we want to help. That was awesome. And then we also have stories. So I want to share what it's like to work with lawyers, to have something scary happen to you. I get the sense that in the world of NDAs, people don't really talk about this a lot, but I think it actually happens more than we think, or more than we know anyway. So I wanted to share my experiences, and hopefully there will be other people who would like to share their experiences, so you kind of know the human side of what it's like to kind of go through this and maybe learn from other people's experiences. There's also resources. This is part where Patent Pandas comes in. So all of those stories will point to specific resources. And these, for example, are about different topics. And inside, so here's one, is what is a patent? And they're explained through these little comics. So for example, one of the things that I wanted to share is all that stuff that I couldn't find online. So if I went online searching for resources, which I did, most stuff that I found was either trying to scare me or sell me something, and usually they were trying to do both. And I wanted to create something that was not trying to scare or sell anything to anyone, just to give good information so that people can make their own choices about patent law. And that's why we're telling all of this. All of the information is being reviewed by legal experts so that we know it's good and worth putting up. And then everything is taught through these amazing panda comics so that they're a little bit easier to take in. So for example, and then all the information is stuff that is kind of counterintuitive because patent law is so counterintuitive. So you have a patent, and maybe you probably know that a patent is kind of the right to prevent others from using a particular invention, using, selling, importing, making, technically. But what you might not know is that just having a patent doesn't mean you can actually use it. So for example, Giant Panda comes up with the cool idea to put a rake and an umbrella together to make an umbrella rake, and Giant Panda gets a patent on it, right? And the Giant Panda is very happy. Unfortunately, Red Panda has a patent on a rake. And so since a rake is part of the umbrella rake, if you don't have access to all of the patents that make up something, you can't actually do it. So here's Giant Panda, kind of sad. However, if Red Panda is like, oh, I'm gonna make umbrella rakes too, but then, Giant Panda has the patent on umbrella rakes, so Red Panda also cannot just make. And so, it leaves the situation, can be kind of sad because neither party can do what they want. And unfortunately, this happens a lot. But what it is trying to encourage, I think, is for inventors to work together, to cross-license, to share their inventive rights, and maybe, benefit everyone by sharing. So you can do things like cross-licensing and patent pools. I will note that a lot of this is still kind of an exclusive thing because guess what? To even get a patent in the first place to cross-license is really expensive. Easily costing, a cheap patent is $10,000 probably, will probably cost more and takes about 2 or more years to get. So they're not easy things. You kind of have to have resources to begin with to participate. So that's an interesting one. I'll show you one more, umbrella rake, but I can go on forever. Another post that I thought really interesting was open versus closed. So when I hear patents, I'm like, no, it means you can't do something because it's patented. Actually, what a patent does is it gives you the right to decide. So you can think of it as someone who owns a piece of land. Someone might say, get off my lawn, like, don't come play. That's how patents are typically used. They're like, you can't come here, don't use my invention, don't come onto my lawn. However, you can also be a patent owner that decides to let everyone use your invention. You don't you kind of don't prevent anyone. This is like an open patent. So like you turn your land into a public park. Anybody can, come hang out. And of course, and then there's the option of not patenting at all, and that's kind of like this like wild land with no one claiming rights over it, and that's kind of the most open option of all. Of course, then there's the issue of other people coming along and claiming it. And that's kind of hairy. So there's a little tiny panda in the distance with a flag ready. In reality, there's a spectrum. Someone can say no, you're not allowed to use. They can charge a fee called a royalty, or they can allow people to use it for educational purposes if they make it clear, or they could just be like, yep, all my patents are open, and there are ways to open license patents too. So I thought that was interesting because initially I was like, oh, patents, bad, or I'll like stop, right? But no, actually it just gives you the right. Again, because they're so kind of expensive and challenging to get, they're not the most accessible things in the world. There's lots of other stuff like that I won't get into, but so you get the idea. So that's kind of our resources. And then, so you can learn, you can read stories and like commiserate with others. You can get help for yourself. And that's the idea. And I hope that there are folks who, if you're interested, we are looking for people who want to, contribute resources or contribute stories. That would be super amazing. And I guess with that, I would like to give tons of thanks, or if I can find my mouse. Here we go. Play. Did that work? Boop. Yeah. So I was going to say, like, this was not a project that I did by myself. It took a huge village. And I've already noted some people, Joey, who has left, but he also kind of was supportive through the entire experience. Kate Darling as well. So there's my legal experience, right? When we were going through all this, I talked to Andy, I talked to Joey, Kate. My collaborator, Bunny, had a lot of experience. He was kind of suffering as well in the case of Chibitronics. But we had so much help. Andrew Torrance, another law professor who connected us to these awesome law clinics all over the US until we ended up working with the Stanford Law Clinic on our case. It was really, really amazing how people were excited to help. And so I just want to thank all of them. And there's so many other people, even in Patent Pandas. Let me think. There's Carol, Lynn, and Jess Field. Oh, I wrote it down. Here we go. Jess Field from the Cyber Law Clinic at Harvard. There's Ben Virgin and Lolita Darden from the Suffolk Law School. From the USC Law Clinic, Caitlin Devereaux, Austin Stanley, and Jeff Perlman. They were actually helped review all these posts, make sure it was good. So like, I'm utterly indebted to them. And again, Andy, because he gave us advice on what to write about. With that, and of course, I would like to thank Joe P., my advisor, who was there when I was a PhD student suffering through all this and helped kind of talk me from the edge, as well as Mitch Resnick, who provided me the space afterwards, and my mentor, Sally Rosenthal, who also had a lot of experience and just like kind of dealt with a panicky version of me, which is not very fun, but like I'm so grateful. So these are all lovely, lovely people who helped me get to here. So with that, I'd like to invite Joe up to share a few words about, so Joe has been around at the Media Lab. Joe P. is professor at the Media Lab of the Responsive Environments Group, and he's kind of seen a lot of these situations perhaps come and go and has a lot of experience within IP law as well. So I was hoping he could share with us just some thoughts about how this connects with research and the experience as students and as an academic doing innovative work, and then we can break out to questions. Thank you. Yeah. I guess we'll share this. Sure. Yeah.
Thanks, Jisha. I'll have a seat. Okay. I've got nothing formally prepared, but G and I talked a lot. We've hung out since and during and talked about patents. My experience with patents has been in many different areas. I I've got a bunch, having been MIT faculty and researcher for many years, so we file. And when we do, most of what I do, I file on very little. We file maybe 1 or 2 patents a year. When we do it, we tend to see something as a potential product. If it looks like it's enabling research, it has a lot more left before it really anneals. I don't really know what I would patent. We just let it go. We publish. We publish on everything. But if it feels like this could be a product one of our sponsor companies in the Media Lab, for instance, could run with, or a student could do a startup around, then we'll file a patent. So I've been through that process. I was head of the IP division here, or the IP group at the Media Lab for a while, so I kind of dealt with everybody's patents and lots of these stories for a while. And the last 5 or 6 years, I've been spending a small amount of my time, like many of us MIT professors with gray hair, have done a lot of work in areas that have become big and commercial, like in my case, wearable sensing. We get asked to be expert witnesses all the time in patent cases. So I, the last few years, said yes to some of them, gotten involved, and really have seen on the other end in intimate detail how patent cases are actually prosecuted and what people do about patents. As a matter of fact, what I generally do is I basically take patents out, I blow them away. So I know about the prior art, I've been working actively in the field, and 80% of the patents that go through IP review, this is the streamlined patent review that doesn't involve district court, which is a cheaper process. Still, we're talking potentially 100K, on the hundreds of K. So it's a corporate level thing. 80% of them get blown away because they're bad patents for exactly the reasons you say. It's not always a malicious inventor. Matter of fact, what you talk about here are cases of fraud. This is outright fraud. It's not just somebody innocently stumbling into an idea. The idea is already there. They don't know. They file a patent. The examiner doesn't know. The patent gets granted. There's an excuse there because somebody is just out in the woods and not doing their homework, and they file a patent. These people knew, and they ripped you off. So that goes deeper than just innocently stumbling into your woods. I mean, this is to some extent fraud. So there's a deeper set of issues. I'm not a lawyer, but that goes deeper. But yeah, there are a lot of patents where basically they didn't know what was around. Inventor writes a claim. Could be somebody working in a company writes a bunch of claims. But no, if you're working in wearable computing, especially with the stuff that I was doing back in those days, yeah, we all kind of did this. You can't just say that this patent is bullshit. Pardon my language here. It's patent panda after all. This is bull. You have the emoji, bull emoji. Because we all know, look at this paper. No, you have to make a detailed argument. You have to go claim by claim. You have to talk about exactly how the prior art relates to the claim in particular, and you have to do it with the right nomenclature. So this is what lawyers do. They're very good at it. I still can't really write like that completely, although I work on these documents all the time. It's a careful process, and every claim that's there, if it's dangerous, you have to shoot it down with this argument. And I mean, you see patents used. Companies use patents. And I see there's a reason for it. I'm not anti-patent. I think patents can be used in terrible ways. I mean, I am anti-gun in many ways, but there's that argument, right? Guns don't shoot people, blah, 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 blah. I don't buy that one. In patents, though, it's one of the ways the companies interlock. It's one of the ways they relate to each other, right? They each have this whole suit of armor of patents. And when they come, into clash around an idea, an application domain where they're building product, the patents are the ways that they basically decide to work. One of the ways they do that, right? So, you had that great idea where they share, like cross-license. That oftentimes happens. Sometimes it happens painlessly. Oftentimes it starts with a skirmish where you hold your patents out, they'll hold their patents out, they'll hire someone like me to blow away their patents, they'll hire some other professor to blow away our patents. So it's a whole battle, and it escalates, right? There's a district court case, it gets huge. Companies can afford a bit of this. If it gets out of hand, they'll usually settle. How big the companies are, how big the stakes are, that will define when they actually cave and when they settle. It can get to be hundreds of millions of dollars. It can be just some thousands of dollars, right? But it's the way that these companies interact. If you're a startup, and this is one of the reasons why we patent, you want to have typically a portfolio of some sort that defines the area you're doing, that is basically your intellectual property, so that when VCs and other people that you're working with and you want to raise money from, they can see the patent as part of your value, your patent portfolio. So it helps you as a startup. So I think there are reasons for them. the rule of law, I think, in the end of the day is very good for the world. And if you didn't have it, these companies would just bust up each other's property, right? So you resort to violence or means that are physically in the physical world. And patents is in this kind of capital world or intellectual world. So, and that's kind of how they play it out. So I think it's better having the rule of law than not. On the other hand, if you apply it against a lone person like you, it can be pretty intimidating. It can be frustrating. I think for this to be a really deep issue, you have to get typically to a point where they notice you, right? And there are companies all the time that are starting up in areas that are crowded with patents. I work with a lot of them here that come out of the Media Lab. They're too small now to get hit with all these patents that are floating around. They get a bit bigger, companies or even individual inventors that have these patents that work with these law firms that are pro bono or not pro bono, that are just guns for hire. We'll see an opportunity to extract a toll. So they'll go after these companies with these patents that kind of vaguely relate to what they're doing, usually not, but it involves legal proceedings, so they want a settlement. Some sort of a tax can be variable level, right? If you're a troll, it could be a significant tax. If you're just a little inventor, you just want to be bought off for a relatively small amount. So they use the patents that way. When you get big enough to be a target, you're going to start getting patents thrown at you. And not from people like this woman, from people that are just inventors, because there are people that just come up with these ideas, or they think they do. They file some patent, and then they, in order to monetize this process, they try to attach to companies and lucrative enterprises to get some sort of a tax. So you see that quite a bit as well. But you have to get typically to a certain size before it gets to be a problem. By that time, hopefully, you've got a strategy of dealing with this when it happens, because you're more of a company. You're not just G and Bunny trying to do it on your own. So you can, and of course, in your case, you had the resources of MIT if you needed it, right? Because this is work done here. So MIT will defend its research if somebody goes after you. And it's happened to us. We haven't had people throw patents at me, but people basically coming after us, saying, "Oh, we have this thing. We've done this work. Blah blah blah." If it gets to be a threat, the MIT legal office can come in and actually help you. So usually that diffuses it, shuts it down immediately once we get the legal office involved. If you're a lone inventor, again, you don't have that. So thanks to Patent Panda, maybe there's some recourse.
I would like to add a little bit on the scale of things before we do questions, which is that it is actually a really good point. It really depends on the size, because if you think about it, or if I think about it, in my opinion, not fact, people typically go after you. They'll throw lawsuits. They'll send you these cease and desist letters to basically try to make money. If you are too little and broke to be able to pay real money, there's really not that much incentive for them to come after you. And for better or for worse, that's actually something that can make you or me feel a little bit better, where it's like, well, I can keep making, maybe this is right, maybe this is not, but even if it's not, will someone come after me because I have nothing to give? Unless you're harming someone's business or they think they can make some sort of money off of you, there's less of a chance of that. I'm not saying that's always the case. Oh, P.S. I'm not a lawyer. This is not legal advice. This is my opinion, because you can't practice law without a degree. And same with Patent Pandas. It's for educational purposes only. But yeah, I think scale and who you are kind of has a big part of it. So even though, in theory, one might be infringing, and by law, you shouldn't be doing this, in practice, things are often so different. And that's why it's so important to have those Sherpas, actual lawyers, kind of tell you what's the truth versus what's written down. So I thought that was kind of really important, and one of the biggest lessons that I learned. So thanks, Joe.
No, I think that's a great way to put it. You never know, right? People can hassle each other about anything if they're mad enough. But generally, to be a serious target of a patent lawsuit, there's got to be something worth suing. So yeah, you get a company of a certain size, you're going to attract them like bees to honey at that point. But you have to cross a threshold, and then you have some legal mechanism that can just deflect them quickly. Right, little gnats, you just swat them. If there's a snake that's trying to gobble you up, then you have to very carefully. Snake gobbles up panda. You have to very carefully build your defense, and that's more expensive, more complicated. But then you're big enough that hopefully you can deal with it. There's another thing in defense of patents. I mean, look, it's totally flawed, because we can kick 80% of them out without much trouble, right? So it's a flawed system in many ways. The Patent Office realizes it. It's great that we have this new thing with the prior art archive. The examiners really, as you said, they only look usually at other patents. Even working with the patent lawyers, they prefer another patent than some paper 90% of the time, because the lawyers, the patent appeals board will understand another patent right away. a paper you have to define, oh yeah, really what came out then, it really was publicly available. There's a bit more of a process to defend it. Patent's easier. It was obviously there because it's in the system. But this new thing hopefully may make that more transparent. Trade secrets are the antithesis to patents. And this is the thing. If we got rid of patents, companies still are going to have problems. They're going to try to nudge each other out of the way. And, granted, if they can't resort to mafia-style terrorism, physical terrorism, they work with trade secrets. And I've seen a bit of that. And that's uglier. Because a trade secret is more about what's in your head, what's in your employee's head at a given time. If you were working with company A, you go work with company B afterward. Company A gets upset about company B and they sue for trade secret violation. It involves individuals, not just institutions. Patent is about knowledge. Trade secret is about what an individual divulged. It's about he said, she said, not so much about this is prior art, this is not prior art. It's a dirtier trial, and patents, despite their problems, are cleaner. They're much cleaner because they're about. And as an expert, I can say this was known at that time because of this work, and this clearly anticipated this. Sometimes you combine two or three things, one or two things. It's always better just to have one thing. But there's a clear argument this was known in the art, and this claim is useless because of it. And it's about the knowledge, not about what somebody said or divulged. So yeah, patents serve purposes. They're flawed, though. They're not the best way to do it. Maybe we get into the era when everybody is, doing very well with the ubiquitous robot economy, and we all have social welfare. We have to make a living. We can just do cool things because they're cool. I think it's the ideal future of music. Some of us have talked about that. We have to make money out of royalties. That's another kind of IP. You just do the stuff you like, and you're supported to do it. I think the world is so much better off when that happens. If we get there, that'd be great. Until we get there, we're going to have something like what we see with patents.
So I guess, thanks, Joe. With that, maybe I would like to invite my sister May up, and we would love to answer some questions. And for folks who might be tuning in remotely, I have my phone on Patent Pandas, so you can go on Twitter at Patent Pandas and then send us a question if you like. But in the meantime, maybe if there are some questions in the audience, we'd be happy. Yeah.
Recording. First off, thank you so much. This is an awesome resource, and I guess given what you just mentioned about the idea of music and other types of IP, do you plan to maybe expand this later on to look at copyright or other things? I know that you've only had this experience with your personal experience here, but it seems like a really great idea, especially expanding it beyond for other areas that students and other researchers might run into around here.
Yeah, that would be really cool. I have to admit, yeah, we will do one at a time, and this one is the most emotionally, motivated one for me right now. But I don't know, yeah, a copyright cat or something, would probably make a lot. I know we thought about it. It's like trademark turtle. I don't know. It starts with a T, but yeah, maybe. So if we could find the help and the resources, I think it'd be really cool to expand. But
There's also other stuff happening at the Media Lab. There's the Berklee School of Music Media Lab thing that we've done, which is looking really mainly at future copyright and protection of work by individual artists, so that you can get some traceability and remuneration for your work when it actually goes out. So it's more defending the work as opposed to taking down copyright. But thinking of new ways to do that. It's very, very active. Lots of ideas are proposed through that. And it's all open, so you can look into I think it's called the Open Music Consortium, something like that. Yeah. And I mean, I'm not a huge fan of copyrighted music either because, I'm a fan of Negativland, as some of you know, and what they had to go through for really making new works of art out of other people's music was horrible. But, yeah, I like musicians to be paid at the end of the day, somehow.
other questions?
Thank you, G. Seems super helpful, and I know I've heard some of the stories from you in the past, but it's really neat to see it up kind of holistically presented on the website. I have two questions, one of which was born out of an experience that Asaf and I had with Medrec when we were trying to get that patented through the lab. And the question was, we both wanted an open patent. We didn't want to use it because neither of us had the bandwidth, nor do we now, to try to do a startup around it, but we wanted to keep other companies from absorbing it and then meaning that we couldn't use it in the future. But it seemed maybe at the time that the Media Lab was less interested in an open patent because it wasn't a clear case to be made for the benefit of a member company. So I guess my first question is, is there a way, has that changed, or could open patents still be pursued at the Media Lab in some beneficial way? And the second question for you guys is, how is it on the international scene? And do you have thoughts, Joe, in particular about China and IP sharing, or battles between different countries that may or may not respect each other's respective patent laws?
A tiny bit about open patents, since that's the thing that I was trying to research when this project started, which is that the patent itself isn't open or closed, it's what permissions you give to it. So I imagine what would happen is you would get a patent through the Media Lab, and they would have to be okay open licensing it. And my understanding, although I could be wrong, is that patents are really expensive. So a cheap one is 10K, a normal one 20K, a complex one like the one you might have if you were here is closer to 30,000. And as a business model, it doesn't quite work. That would be my cynical view. I don't know, perhaps the policy is different. But at least when I think about the technology licensing for MIT as a whole, they think I've kind of talked to them a little bit about open source, et cetera. And they were like, yeah, if you don't want to patent something, we're not going to make you. But, if you do, we want to make money from the patent that we got. So that was the reaction that I got from the higher level technology licensing here at MIT. Maybe the Media Lab is different. Maybe, Joe, you can add to that.
Yeah, I think G hit the nail on the head, and that for us to do a patent, we have to invest money behind it, and significant money. And usually we want the argument in IPCOM, the IP committee that meets here, why you want a patent. And typically it's for defend a startup or to work with a sponsor, something of that sort. In this case, there are lots of people interested in MedRec, so I don't know exactly why. I think your advisor wanted it to be open and maybe didn't like the idea of patenting for that reason. I mean, one other possibility is to file a really bad patent. So people file provisionals all the time, which are just the paper. So you could sit down and just write your paper and then make up some claims, whatever, you don't care. But the prior art aren't the claims in the patent. No one cares about if using patent for prior art about the claims so much. It's the disclosure. So it's what you write down before that. So you could write down whatever you want before that and then just make up some claims. It would get rejected, but it's going to be there as prior art, and that disclosure is always there. So that's...
Something to add on that point, a clarification, which is that you can make prior art by publishing research papers. You can take that provisional patent if you got one and just put it on your website and archive it on Wayback Machine. If you just submit it to the USPTO as a provisional patent, that's actually not prior art because it's never published. And the USPTO doesn't actually read provisional patents, so they wouldn't know about it. So it only becomes prior art if you publish it on the web where other people can access it. It's a very strange quirk.
Yeah, provisionals are weird. They're only good when you get a patent issue because it gives you a priority date. But if you actually file an application, you can make a crappy application, and that would work. The application would be published. But it costs money to file an application, too. That's thousands of dollars. It's not 10,000 maybe, it's a few thousand. And then you have to maintain, but you wouldn't maintain it, you'd abandon it. So it's just a filing fee. I think this new idea, if there are ways of alerting examiners, I don't know why they just look at other patents. I mean, there may be some legal argument, but... Yeah, time is the big deal. I've dealt with examiners. Actually, one of them even called me at home because he wanted to resolve a claim issue, wanted to talk to my patent lawyer, and he had retired, couldn't get a hold of him. It was amazing. This guy called 9 o'clock. He's blah, 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 patent examiner. What? It was a fake call. But, he talked about the patent. He knew about it, so it really was him. But, yeah, these guys are under the gun. And what lawyers will do, we talked about that, they'll wear them down. So if you are working with a firm and they want to get their patents accepted, so the law firm is going to try to get them accepted. Even here at the Media Lab, we do that. You quite often will get rejections on the claims. Sometimes it's because the examiner doesn't get them. Sometimes he has good prior art. But there's always a dance. And if a company really wants that patent, they're going to wear the lawyers will wear the examiner down. They'll keep doing new appeals to office actions, and they'll change a few words here and there. And eventually I've seen cases where just the examiner gives up and the patent is issued, even though it's clear the examiner's right to reject it. He's rejected it 4 times, 5 times. He's come up with different patents, different reasons. They change a few words, and eventually says, I'll let you have it, because he's under pressure probably, and the patent gets out when it really shouldn't. And there's a job of people like me to doing IPRs where we kick them out. But that's, a lot of careful work. Whereas the examiner, if he was able to do his job properly, would have kicked it out. I'm just trying to kick it out. So better tools for examiners to reject patents that are bogus would be wonderful. And bringing in other prior art is a good way to do it. We're living in an area of ubiquitous knowledge. If we can bring more of that to bear, I think we'd have stronger patents that are real patents, and ones that are just redundant. Ideally, wouldn't make it all the way across to make trouble. For international stuff, that's a great issue. I mean, very current issue, and I'm not an expert in that. I mean, we typically, if a patent is important to a sponsor company here at the Media Lab, we'll enable a PCT to be filed, which lets us file patents around the world. At least, you know, we get like a year or so to file them in the EU and China, wherever we want to do it. It costs money for that, so we don't fund it ourselves. We have to get that money coming from the company that wants to license the patent.
Tiny bit, just explain what that means. So if you're not super familiar with patents, you may not realize that patents only have say in the country that they're filed in. So you can get a patent in the US, you can get a patent in China, and in many other countries. So, but if you have a patent in the US and you don't have one in a different country, you don't have rights to that invention in the other country. A PCT is something that you can file when you first file your original patent that says you like hold this spot. You reserve the right to be able to apply for those same patents in all these other countries. You can imagine it gets pretty expensive to try to get a patent in each of the different countries, which is probably why people typically don't. So it's kind of a tricky situation. I just wanted to give that background.
Yeah, and patents in other countries can be used as prior art too. So German patent, I've been on cases where German patents are used to halt other patents or patents from various places. The other thing that can happen is a defense. I don't know if we can go after products in China. There are probably ways. There's more diplomatic pressure working with companies that work in the U.S. and China together. But we can halt products at the border here. And I've been involved in cases with the Federal Trade Commission where, you know, there's a violation and you can go after people that way. Instead of going through patent court, a district court, or IPR, so on and so forth, you can actually go to the Federal Trade Commission and say there's a violation and we want to stop the patents at the border. So even though it's made in China, blah, 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 this is a violation of our intellectual property rights here, so I'm going to stop these products before they enter the U.S. That could be something inside of an iPhone, for example, right? So it's an American manufacturer, it's made in China, but there's some issue about the IP with this thing and some part of its chain, so you can stop that thing at the border before it comes in. It could be a trade secret too.
Maybe I'll add two more comments. I'm also not an expert on international patent law, but I do understand that, like, what was I going to say? So in China, there's also a patent system, and so people can apply for patents. My understanding is that it's very hard for someone who's not a Chinese citizen to get a patent. So you have to like find a sponsor there. So it's like super complicated. It is like very hard, and I think that's probably some of the issue. I don't know. I am not an expert. A kind of interesting anecdote though is that people seem to really believe strongly in the U.S. patent system, and so one reason why many people in other countries might get it is because it's like, hey, if your invention is valid enough to get a patent in the US, there must be some legs to what you're doing. So that's kind of one part where it might come up, but again, not an expert. Other questions? Oh.
Hi, absolutely fabulous. I'm thrilled with the website you've put up and also your explanations of all of the patent stuff. I actually head up the licensing office here at MIT. And so I have two questions. I have two questions for you. One is, can we do a link from our website to your website? Because the way in which you've described this stuff is exceptional, and it's the sort of information that we would love to get out there for everybody. I mean, I was very interested in your stories too. And the second thing is, have you thought of doing this show on the road? Because, I'll be more specific. IAP is coming up in January, February, and I think this session would be extraordinarily helpful for people, and I'd be happy for the TLO to sponsor a presentation to students in January, February, whenever that session is. Because one of our efforts is to get information out, although we are usually getting involved in patenting of research of faculty and not students. People come to our door all the time. And so what we've been trying to do over the last couple of years is provide more generic information about this topic, because, you're starting companies. Whether or not MIT owns it, quite frankly, is irrelevant. The more knowledge we can get out there, and I think this tool that you've got is fabulous. So if you're interested in that, I'd be happy to talk to you. Yeah, no, my pleasure. Congratulations to you all.
Everyone is absolutely invited to link this. Everything is under Creative Commons, so like share out, use it, whatever you like. And thank you. Yes, that would be so cool. And I guess just a few words on that. I mean, my experience is like I wasn't thinking about patent law, but I like to make projects and get them out into the world. And I feel like as crowdfunding and the internet allows every one of us to be an entrepreneur in some way, I feel like this is going to become more and more relevant. So my hope is to make it a little less bumpy for everyone else out there, fewer glass walls to smash into. Cool. Are any other questions? Or I think that's time. Or was there one more?
Actually, I have a question. What would you say to people who say the rake and the umbrella example is just too ridiculous?
Thank you. So you may, we were brainstorming what should Giant Panda patent, and Ira was the one that suggested the umbrella rake as a joke, and we kind of went with it. There's a patent on the umbrella rake. It was accepted and issued in 2014. So just so you know, welcome to the world of patents. So I guess with that, thank you all so much for joining me. Hopefully this was an entertaining educational experience. Thanks, Joe, for your support like the entire way from the very beginning. And before that, thank you, Mei Mei, for your awesome pictures and making it as accessible as it is. To Ira for also facilitating in so many ways. And to the Media Lab and the Berkman Klein Center and Andy and all these lovely people who help when things go wrong. As my partner likes to say, and as Mr. Rogers likes to say, when things are going wrong, look for the helpers because they're there too. So that's what this is about. Thank you. Oh, and with that, reception downstairs. 5th floor, cafe. Right. Thank you. Thanks for joining. Bye.